Hello, everyone, and welcome to CoastWA training on coastal planning. This is presented by Anna Kelderman from Shape Urban on behalf of CoastWA, which is supported by the Department of Transport and the Department of Planning, Lands and Heritage and WALGA. We would like to acknowledge the traditional owners of all the lands on which we work, their connection to country and lands, waters and skies, and the enduring relationship with everything which we are lucky enough to share. We aim to respect this in all the work we do. This training session will run through a quick introduction about why we undertake coastal planning, about what type of coastal planning fits your needs, how it might be undertaken, when you would develop certain plans, including a Coastal Hazard Risk Management Adaptation Plan or CHRMAP, and what ensures that the planning results in delivery or implementation. This module recognises that the coastal planning framework can be complex to navigate regardless of skill sets and experience. That good coastal planning delivery helps build coastal literacy, knowledge, awareness, and support for coastal adaptation. That coastal management is an essential part of risk management. That the community are becoming more involved and are becoming more educated, and coastal managers need to be proactive where possible. This training module has been prepared primarily for local government authorities, coastal managers, and elected members who are responsible for coastal management, recognising the variety of technical disciplines and decision makers who may be involved. As a guide for consultants working on projects with coastal elements, and as a guide for community organisations who may want to lead community-based coastal management initiatives. Information can be found in a number of documents, which we will go through, including the WA Coastal Zone Strategy, the State Planning Policy number 2.6, State Coastal Planning Policy, the State Coastal Planning Policy Guidelines, and a series of other supporting guidelines and manuals. This slide just illustrates the number of different areas within the planning system that coastal planning is considered. There are a lot of dependencies and interdependencies, from the top left at very high levels, all the way down to the individual property on the bottom right. It includes a number of very technical documents and more flexible local coastal planning documents. The end result, if coastal planning is done early enough in the system, is that the end provisions that lead to development at the local level are done in the context of good, proactive coastal planning. This diagram is not designed to cause pain, but is complex, and we'll come back to this at the end of the training session. So coastal planning, why, what, how, when, and what then? This session tries to break it down. The broader coastal planning framework, clarifying why we undertake coastal planning, what type of coastal planning fits your needs, how it might be undertaken, when coastal hazard risk management adaptation plans or CHRMAPs and other documents are required, and what ensures that the planning results in delivery and implementation on the ground. On a general note, why do we do it at all? It's very clear that the coast is always changing. However, more regularly now, long-term trends are impacting communities. Most communities that are undertaking coastal management, or CHRMAPs, are not doing it for fun. CHRMAPs and coastal management projects are rarely fun. The community is worried about their own assets, worried about public assets, worried about the environment, and worried about safety. It is fundamentally about risk management. For good coastal management, by coastal managers, and communities that demand action. And coastal management can cost a lot of money, so we may as well get it as right as possible. Key inputs to coastal management in WA, as shown on a previous slide, include, under the planning components, SPP 2.6 and related instruments, which sets policy intent, defines acceptable coastal risk and adaptation pathways, and applies these through statutory planning and approvals. Engineering and science support by informing impacts, testing options, and, where endorsed, designing and delivering site-specific responses to manage coastal hazards to defined levels of service with residual risk. Economics informs values, cost-benefit analysis, and benefit distribution analysis. In practice, Planning, engineering, and economics inform each other iteratively, but planning provides the decision framework within which engineering and economic advice is considered. Okay, so let's get into a little bit of key terminology. So there are 4 identified key adaptation responses, plus a couple of extras. I'll get to that. The first is avoid. So identifying future no-build areas. It's pretty simple. Just don't put it there if it doesn't need to be there. The second in the hierarchy, so this is preferential and sequential. Second in the hierarchy is planned and managed retreat. So to withdraw, relocate, or abandon built assets that are at risk. This is an incredibly complicated option because it means in some cases removing assets that are much valued by the community, and in other cases it implicates private landowners and relatively significant public assets. It can be quite costly, but it has the impact of removing the risk or the vulnerability entirely. Accommodate is the third in the hierarchy, and that is to continue to use land but implement different building and adaptation responses, such as building on piles, so the old Queenslander style house, or modifying the landscape in some way. And the last option in the hierarchy is using hard structures. So the things that we're all familiar with, like seawalls, levees, and then other options like sand nourishment and revegetation. Again, quite expensive, and protect is not a permanent adaptation option. So it's something that you need to consider both in terms of capital expenditure and maintenance expenditure, and then replacement cost. Essentially, I'm including this here because the language is used throughout the first half of the presentation, and in particular, it's important to recognise that avoid, plan and manage retreat, accommodate are in the overall planning discussion, whereas protect is more about physical responses and adaptation. There are 2 other adaptation responses that are discussed, and one is no regrets. No regrets is pretty simple. We're talking about doing small actions that support the broader coastal planning response. So that can include things like monitoring, it can include things like emergency management planning, it can include developing other plans that allow you to modify your coastal foreshore. And the last one is do nothing. And that means exactly what it says, do nothing and accept the potential risk that coastal hazards will impact assets. Okay, so a bit of an overview of the key documentation. As before, where do I find what I need? There is a suite of documents. There are some links here on this slide, but essentially they are all stemming down from the WA Coastal Zone Strategy through state planning policy and then guidelines. So the WA Coastal Zone Strategy is a high-level document. It sits at the state level. It identifies the intent of integrated coastal planning and management. It focuses on ensuring sound planning, management, and use of the coast for the benefit of current and future communities. It identifies the visions and goals, environment, community, economic and infrastructure, and objectives of coastal planning. It identifies key issues, including things like uncontrolled access, impacts of climate change, and liability. And it also outlines the state government position on protection, referring to State Planning Policy 2.6. And to be clear, what that means is that it is the highest level of strategy position in terms of identifying the preference against protecting private property. And it identifies the broad roles and responsibilities of government, private organisations, natural resource management groups, and the community. So the WA Coastal Zone Strategy sits within the West Australian legislation context and it drives all underpinning strategies and policies. Just a small number of the legislation that interacts with the WA Coastal Zone Strategy and its and the legislation that stems from it. Obviously, the Planning and Development Act, the Land Administration Act, the Planning and Development Local Planning Scheme regulations, the Marine and Harbours Act, Port Authorities, etc., etc. And of course, it crosses over into a number of environmental legislation, such as the Conservation and Land Management Act of 1984. And that's due to the fact that coastal hazards also impact the natural environment, and the capacity of the natural environment to adapt to change. And so these elements are interdependent. And the WA Coastal Zone Strategy then gives rise to the legislation that sits under State Planning Policy 2.6, State Coastal Planning, State Coastal Planning Policy Guidelines, the CHRMAP Guidelines, generic scopes, and then is the overarching document that guides any amendments we might make to local schemes and strategies and local policies. So State Planning Policy 2.6, State Coastal Planning Policy, is our guiding legislation. It was gazetted in 2013, which replaced a 2003 version and its 2006 amendment. It provides guidance for decision-making within the coastal zone, for managing development and land use change, for the establishment of foreshore reserves, and to protect, conserve and enhance coastal values. The objectives of State Planning Policy 2.6 are to ensure that development takes into account coastal matters, ensure the identification of appropriate areas for the sustainable use of the coast, to provide for public coastal foreshore reserves and access, and to protect, conserve and enhance coastal zone values. For coastal matters, State Planning Policy 2.6 or SPP 2.6 is the higher order and prevailing policy over all other state planning and development control policies. It's also worth noting it is under review and there may be some changes to it in the coming years. SPP 2.6 highlights a number of elements. The first one is new development is to be discouraged in the coastal zone. And of course, the coastal zone is not always known at the time that one is doing coastal planning, so that's a to be determined. But essentially, yes, discouraging new development in the coastal zone, i.e. avoid. Then it establishes the possibility that some development which is dependent on the coast may be considered in the coastal zone. So this is talking about things like surf lifesaving clubs and ports and other things that are coastally dependent. It establishes that commercial and recreation uses must be sustainable in the coastal zone and that infrastructure, land use and development should complement and enhance the coastal zone. Essentially, what SPP 2.6 is saying is if you're going to do something in the coastal zone, make it the right thing. And that last dot point there, to avoid negative environmental impacts, is also quite important. And again, you see that crossover, that interdependency with other environmental legislation there. Most importantly, for a lot of our conversation, State Planning Policy 2.6 asks that a coastal hazard risk management and adaptation plan occurs where it's required, obviously in the coastal zone. So that's a coastal hazard risk management and adaptation plan, or a CHRMAP. Underpinning SPP 2.6 is a set of guidelines, so State Coastal Planning Policy Guidelines. It's essentially the document that provides the information that supports the policy. So it's there to assist in the interpretation and application of SPP 2.6. It's there to assist in determining appropriate land use and development, in specifying requirements for adequate foreshore reserves, and ensuring coastal planning measures are included in decision making. As with its state planning policy parent, SPP 2.6, it's also under review. A large part of this training module is brought in from this guideline document, and it is a fairly detailed document that provides a lot of information for users. The guidelines are very clear that SPP 2.6 is relevant to every stage of the town planning process. And I guess I need to sort of be very clear that we're talking about town planning and the urban planning that sits within the legislation of the Planning and Development Act. Importantly, the policy guidelines note that there is an increasing level of detail required in coastal planning from the top left to the bottom right. That is at that high-level strategic level, at the state planning level, we need to at least consider coastal planning and coastal hazards. And then as we get into a more local planning, we need to undertake more detailed investigations. For example, at that local planning strategy or at a region scheme level, in both the strategic and the statutory planning sense, we need to start looking at coastal hazard risk management adaptation plans, so CHRMAPs, potentially even coastal planning strategies or foreshore management plans, so CPS or FMP. And then it also looks at the more detailed planning that might happen in the statutory sense at a very local level, and that can get down to individual development applications. The guidelines introduce planning instruments, considerations for subdivision and development, CHRMAP, the relevant authority and conflicting information, so that gives you an indication of which is the higher order legislation. The policy guidelines talk about infill development, which I'll touch on, coastal protection works and benefit distribution. And then it talks about things like where it is in the public interest, i.e. for public access, coastal roads, car parks, pedestrian access, dual access paths in the foreshore, and of course, more directly about coastal foreshore reserves and coastal foreshore reserve planning. And this is also where it introduces the concept of coastal planning strategies and or foreshore management plans. In terms of coastal foreshores, Clause 5.93 of SBP 2.6 seeks to ensure coastal foreshore reserves are set aside for public ownership, for management, public access, recreation and conservation. The guidelines are very clear about public interest, allowing for some development that can be removed by the relevant impacts based on design life. For example, things like car parks and paths, provided that they don't make the impact worse. One of the other interesting things that the guidelines introduces is it suggests limits to coastal pedestrian paths that run perpendicular to the coast, and suggesting a minimum of 150 metres apart unless the context requires otherwise, and it should be part of a management plan including viewing, seating and universal access. The guidelines suggest that dual-use paths should not fragment vegetation, should be safe, avoid clearing, and demarcate private and public land. And I'm going to show you an example of that right here. This is an example in Port Hedland. You can sort of see a little goat track along the front of those properties as it interfaces with the coastline. And that's the track there. And the town of Port Hedland wanted to create a footpath along there. It is a public area. And you can see that there is already a few of those properties fronting that public reserve who have taken liberties of planting grass, etc. But it was important for the town to demarcate the difference between the private land and the public foreshore reserve, and so they did in fact introduce that footpath. It was not done without a bit of a battle with those property owners, but again, it's important to identify what is private and what is public land. An alternative example is one down south near Dunsborough, or halfway between Busselton and Dunsborough. Again, a foreshore reserve that had identified a path that would go along the waterfront. And in the end, that one was not introduced due to landowner pressure. And in this case, public access doesn't exist, and it does not feel as if the public is permitted into that zone. The State Coastal Planning Policy Guidelines also introduce the concept of coastal nodes. So it identifies 3 different types: a regional, a district, or a local coastal node. It uses the example of Busselton for the regional node, so suggesting a fairly significant node with a lot of activities, things like restaurants and parks and lots of parking, showers, etc. It uses Trig as the example of a district coastal node, so smaller scale, some of those same functions and features, but typically a little bit more local attraction, so from the neighbouring suburbs. And then it uses Yallingup foreshore as the local coastal node, a fairly simple foreshore node with a playground and some seating. So those scales of significance based on the kind of regional attraction that the node might have. The preference is for coastal nodes to be held in public ownership. However, there may be circumstances in which they remain in private ownership for a period prior to being transferred to the public realm. So during subdivision development, a landowner subdividing land may seek to hold on to the foreshore node and develop it for some kind of commercial activity that they have some control over. But the policy guidelines note that it's only acceptable where the coastal node is in an existing zoned land intended to become a coastal foreshore reserve in the long term. So that might be an area that was already zoned, and when the subdivision occurs, the coastal zone is identified, which eats into the zoned land, and the landowner may seek to get some benefit out of that zoned land in the short term, with the full knowledge that it will become coastal foreshore reserve in the long term. Appendix 2 of the guidelines outlines how this might occur. It talks about triggers for delayed vesting. So at a certain point in time where the coast is within a certain distance of the most seaward part of the coastal node, to ensure there's sufficient time to cease use and to remove development and rehabilitate the land and vest it to the Crown. There is an existing case law which provides for this, and that is a Two Rocks decision, which is noted in some of the fact sheet content. Some of the other conditions, typically that there would be no subdivision of the coastal node zone, that land uses are restricted, and that there would be time-limited approvals placed over any of the activities in that zone. Typically, there would also need to be a foreshore management plan. And the last dot point on that page talks about the time in which the zone has to be included in the scheme within less than 6 years, or the land would be forfeited and the land ceded free of charge. In any case, if a coastal node zone is held in private ownership, the cost of establishing any of the infrastructure is private. The cost of maintaining any infrastructure is private until it is vested in the public realm. The cost of maintenance of any infrastructure is private until it is vested to the relevant coastal manager, and the cost of rehabilitation to a natural environment is private. Okay, CHRMAP guidelines. So this is a set of guidelines for how to develop a coastal hazard risk management adaptation plan. It includes the templates for consultants and different planning responses that might be introduced as a result. And there is also included a series of different consultant scopes of work. Now, the Coastal Planning Management Manual, it's a pretty old document, but it still stands the test of time. It's full of tips and tricks, particularly in the areas of things like Indigenous participation, common coastal management problems, the different types of stakeholders that might have interest in coastal hazard management, and any foreshore management planning elements that might be introduced. The question is always why? Why are we doing this thing? So we get asked why we are doing this sort of thing all of the time, and this is the why. So images here, this is Geraldton, damage to a road. This is Eton at a high tide, inundated foreshore. This is Albany, a erosion front after a big storm, losing a decent proportion of the primary dune. This is Broome on a high tide after a bit of rain. You can see the damage that the inundation might be doing to the road infrastructure. Bunbury, again, after a big storm, and you can see that building in the background there, probably a little bit nervous as these sorts of storms roll through. This is Lancelin. You can see the sea rescue building in the background there, which is really coming under pressure over more recent years, and the erosion in the foreground that is consistently impacting Lancelin. And lastly, the image you see here is from the Cocos-Keeling Islands. This is on a pretty low tide, but you can see that the island is fairly low lying, and it floods quite consistently. All of these examples are common examples that we see around the place now, and communities are starting to say, what are you going to do about it? And that's our job. So coastal planning is an important part of our role here. So some of those common issues, you see beach stairs that get damaged during storms, so closed for safety. You will see the parklands slowly eroding into the sea, for example, some in Albany, the image that I showed you in Lancelin. You'll see coastal car parks being impacted. So Port Beach is a pretty well-known example. Things like ocean or estuarine water coming onto land. Coastal roads being affected by undermining. For example, there was the Geraldton example that I showed you, and then another one, obviously Seabird, which is a well-known example. And then where we really start to see things becoming complicated is where we see private assets and properties slowly being lost, or at least losing setback distance to the ocean, and those property owners becoming pretty nervous. And of course, the big one is when we start to have concerns about human safety in significant storms, for example, like on the Cocos-Keeling Islands. So it's fundamentally about risk management. So coastal planning is one of the risk management tools that we have in our arsenal. and all coastal managers are obliged to consider the risks that they're facing when they make decisions. All right, so we've talked about it a little bit. I'm just going to go into a very quick 101 of the CHRMAP process. Of course, there is several training sessions about this specifically, and I really encourage you to have a look at those. So a CHRMAP is a coastal hazard risk management adaptation plan. So coastal hazards, what are they? So it's identifying them. Risk management, what are we responding to? So what are we concerned about? Adaptation, what are the options to respond? And plan, what do we do next? So CHRMAP is one of the earliest forms of coastal planning to be undertaken in the planning continuum. If we get this sort of higher order coastal hazard plan done, then all of the underlying planning can be done in the context of that plan. They are needed to manage risk for future development, regardless of how far into the future that development is. This is a standard CHRMAP process, 7 stages in the guidelines. What we start with is that modelling, so modelling the risk of erosion and inundation, plus predicted sea level rise over 100 years. We identify the likelihood of exposure on any assets, and assets being both built and natural, and values that we place on the coast. It identifies the consequence of exposure on an asset. So how much of an impact is the damage, or is the impact to the asset really going to be? It considers how adaptable the asset is. So is it easy to move? Is it difficult to move? And then makes recommendation for how to respond. A couple of really important things there. Firstly, modelling the risk of erosion in inundation and predicted sea level rise. So it requires that we look at predicted sea level rise over 100 years. So in 50 years, sea level rise of 0.4 of a metre, and by 100 years, 0.9 of a metre, and 0.2 of a metre per year uncertainty for future sea level rise. They're fairly significant numbers. So for a CHRMAP, the 100-year time frame is non-negotiable. That means you have to do the long-range forecast. But it is important to recognise that the model is not a prediction of a future coast. It is a projection of areas potentially vulnerable to coastal hazards in the future. Within SPP 2.6, the non-negotiable is the 100-year time frame, but it also talks about protection and enhancement of foreshore reserves for public benefit. CHRMAPs are highly technical, so consultants are typically required. It takes a long time, and the types of consultants that are usually required include planners, coastal engineers, economists, stakeholder and community engagement specialists. Again, these are the adaptation responses, so avoid, plan and manage retreat, accommodate and protect. Sequentially, we prefer avoid, our least preferred is protect in the hierarchy. Some common actions that come out of CHRMAPs are in future investigations, so sand and rock source investigations, other flood and groundwater investigations, geotech, beach and dune surveys, and different monitoring, so monitoring photos at the same time as other beach monitoring. Common outcomes of a CHRMAP in terms of planning actions. The first 4 here. First one is notifications on title, and that's simply creating the scenario where you can place a notification on the property's certificate of title, which is a land tenure matter, and just warning people through that notification that the property is at risk. Limited planning consents, in particular, the Planning and Development Act allows for time-limited planning consents, i.e. this development is approved until X date. That can be paired with an event-limited planning condition, which essentially says this event might happen, and I will show you some examples of that later. Foreshore management plans, often recommended where there is a coastal node or a foreshore that requires active management. And then asset audits management plans, which is pretty common. That's a no regrets recommendation, which is essentially suggesting that you pay careful attention to where your assets are in the coastal zone. Then emergency evacuation planning, as I mentioned before, that's a no regrets option. And that is where you might imagine that there could be some inundation or emergency response to erosion where the community needs to react, and it's better to have a plan rather than for them to react in an ad hoc way. This next one is a big one. This is the special control area recommendation of a CHRMAP, avoiding further development and managing development in that special control area. I'll talk about that later as well. local planning policy development, which would support a special control area or in general support coastal planning. Reservation of land, so that is taking land out of a zone and putting it into a reserve in the planning scheme. And managed retreat planning, which I've put a little asterisk next to. That is quite complicated and can be quite controversial, but in reality, all of the other dot points on this page are helping to lead towards a managed retreat or a planned relocation away from the coast to take the risk away entirely over time. Okay, so coastal planning framework and what type of coastal planning fits your needs. This diagram again, just talking through the level of detail which is required. The closer you get to, say, the requirement for development application on individual lots, the greater the level of detail that you will need. So the Coastal Planning Policy Guidelines suggest that SPP 2.6 is relevant to every stage of the planning process, again, just increasing levels of detail. Let's start right at the top, and we'll start with the region scheme or the district structure plan. So these types of planning mechanisms which are looking at things over very long periods of time. So determining in that left column, determining direction for land uses, reserves and infrastructure for 50 plus years. These would typically be for multiple local government areas or across at least two. It's worth noting that region schemes only exist at the present time in the metropolitan region, the Peel region and the Greater Bunbury region. So what is the coastal planning requirement? Essentially what it's saying is a planning assessment should identify the coastal foreshore reserve, so the coastal zone, which can maintain ecological, heritage and open space values. And the planning assessment should also consider the risk management requirements in areas that are proposed for development, for example, within the coastal foreshore reserve, capable of retreating beyond the 100-year timeframe and retaining additional foreshore. In terms of the level of detail that would be required, at this level, it would be preferred that you have at least done a coastal hazard assessment, that is those more technical elements of a CHRMAP, or that you've done a CHRMAP. Bearing in mind that we're talking about potentially multiple LGAs, that might be a bit more complex if not all of them have done a CHRMAP, but of course we are talking at fairly significant scale, so it would be preferable that they are done. The right-hand column introduces the parts of the state planning policy, the clauses within the state planning policy that are relevant, and obviously the sections within the Coastal Planning Policy Guidelines that are relevant. These documents are approved by the West Australian Planning Commission, so it is consistently likely that the West Australian Planning Commission will require a fairly good level of understanding of the coastal hazard requirements or zone. I think it's important to say at this level, the region scheme is often something that is managed and led by the state, although individual amendments to the region scheme might be progressed due to private parties having interest in zoned land, whilst a district structure plan can be done either by the state or by private interests. And either way, the district structure plan would typically require an increased level of detail. What the guidelines also note is that there are some historical anomalies based on the age of the policy. So it indicates that the majority of existing coastal foreshore reserve boundaries are not consistent with contemporary coastal foreshore reserve planning requirements of SPP 2.6. In addition, it notes the need to reassess previously established coastal foreshore reserve boundaries as a consequence of developments in climate science. Reviews of region schemes and strategies and structure plans and regional strategies should progressively include increased allowance for foreshore reserves where possible. So I've got a couple of examples in the following slide, which is two nearby shorelines in Mandurah, showing the difference between two coastal foreshore areas. The first foreshore shows a very, very narrow vegetation strip between the coast and the nearby road. That means that the foreshore does not have room to adapt before the road is impacted. And in fact, those houses, both the ones fronting Ormsby and the ones fronting the rear road, will potentially be at risk within the 100-year timeframe and not give the natural environment room to modify itself over time. In the image on the right, you can see a foreshore reserve of some nearly 220 metres between the coast and the first road, and that ensures that the foreshore has room to move in the normal cycle of erosion and accretion, and also gives all of those asset owners and the coastal manager plenty of time to plan over a much longer period without having to adapt rapidly and make decisions too fast. And this is the image that's taken straight from the guidelines, just showing the foreshore reserve giving space for that 100-year physical process setback, and then a remaining foreshore reserve to allow for continued use and enjoyment, with development quite a way off into the future before it's impacted. And again, this has been tested in a legal setting. Two Rocks Investment Pty Ltd and the West Australian Planning Commission went to court over an increased allowance for physical processes, and the Western Australian Planning Commission's position was upheld in that case. And this allowed for the foreshore reserve identification to avoid future managed retreat, accommodate, protect, etc., and essentially avoid long-term costs to the whole community. What this case confirms is that foreshore reserves are non-negotiable, and they should be determined at the earliest phase, preferably at the highest order planning stage. Okay, the next stage is a region scheme amendment. Essentially, this I touched on previously, to modify or change the existing scheme for broader planning purposes. Again, we're talking about high-level long-term planning at the region scheme scale. It has the same coastal planning requirement, and at this stage, you would assume that if a CHRMAP has not already been done for the coast being considered within the region scheme amendment, that it is required, or at the very least, a coastal hazard assessment is complete. A region scheme amendment would be endorsed by the Minister on advice from the WAPC, and of course, reviews of region schemes should progressively include increased allowance for foreshore reserves where possible. If done in advance for an undeveloped area, this can allow us to avoid development in the coastal zone. If done after development, the reservation of the foreshore could become the basis for injurious affection, which is a landowner could claim compensation from the government for impacting the value of their land. The allowance for foreshore reserves wherever possible enables good quality planned and managed retreat. So then we get to the district structure plan scale. Now, essentially, a district structure plan is developed to address fatal flaws of potential development areas and provide major structural elements, including road layout, open space requirements, and the foreshore reserve. So it's typically within a single LGA, although it could cross boundaries. And of course, the district structure plan could be developed by a local government or even the state government, or it could actually be developed by private interests who are looking at large areas of land for long-term subdivision. The planning assessment should identify the coastal foreshore reserve, absolutely. It should identify any coastal nodes and look at coastal risk management requirements in areas proposed for development. So it may identify need for foreshore management planning as a next stage, and it is almost certainly going to require a CHRMAP to be developed, either specifically for the district structure plan, or if there is a CHRMAP already developed recently, that the district structure plan follows the recommendations and the general coastal modelling included. Having said that, at this scale, because it's looking in a relatively long-term sense, it may be that the coastal hazard assessment is relatively high level and that there might be a need to do further reassessment as the detailed phases of the district structure plan roll out, as each of the stages of the district structure plan get developed into the detail of a subdivision plan. Again, you can see there on the right the different clauses included in SPP 2.6 that are relevant and the different sections within coastal planning policy guidelines. And the WAPC is the approving body. Importantly, district structure planning looks at Appendix 2, which is the appendix relevant to coastal node planning, and specifically talking about whether or not it's possible for there to be private ownership within the planning framework of coastal nodes. So this can actually give rise to conditions of approval that can include development of a CHRMAP or developing a foreshore management plan, etc. This scale of planning is typically undertaken for greenfield areas, and provides for long-term avoidance of coastal zones. So avoiding development in coastal zones. For example, see the Two Rocks legal case. Next down, we have the local planning strategy level of the planning system. This is the document at a local government level that sets the strategic direction for land use planning for 10 to 15 years. The local planning strategy guides any changes to the local planning scheme. So it's quite important that any coastal planning requirements are introduced in the local planning strategy. With a note there that a CHRMAP should precede a local planning strategy. That has not historically always been the case, but certainly would be now. And the local planning strategy should include discussion about the provision for all State Planning Policy 2.6 requirements to be met at the earliest stage of structure planning, subdivision and development. You can see there the different clauses and sections that apply, and the West Australian Planning Commission is the approving authority for the local planning strategy. The local planning strategy should include commentary of CHRMAP recommendations, limits to land use, identify key areas to avoid. It can highlight future protect or retreat plans and indicate private responsibilities and challenges to be met across the forward planning period. And I'll show you some examples. It can include areas that are identified as coastal nodes. It could identify areas that might be coastal nodes where private ownership might apply, and obviously makes recommendations about the kinds of conditions of approval that might be included in any future development. Obviously, the strategy should include allowances for foreshore reserves where possible, so that we can avoid any future development that is impacted by coastal hazards. Next down, we have the local planning scheme and any future amendments to it. And of course, what I said in the previous slide about the strategy being the direction given for a scheme, this is the scheme then that follows. So the local planning scheme sets the overarching statutory basis for land use planning. This is where we get our rules and regulations at the local level. The local planning scheme should include elements of all state planning policy and all other legislation that's relevant to planning. At this stage, we have a very high level of detail of all of the things that we need to manage at a local land use planning level. A CHRMAP should absolutely precede the development of a new local planning scheme that has a coastal frontage, and that should proceed as part of the strategy. And certainly one of the recommendations of that CHRMAP would be to introduce things like special control areas and notifications on certificates of title. And that would be almost a bare minimum if you had a potential coastal hazard impact. The special control area would include development provisions, and I'll show you some examples. You can see there the clauses and the sections that apply. And of course, given that we're now talking about definitely having a CHRMAP, you can have a look at the CHRMAP guidelines as well. The endorsement of the local planning scheme and any amendments to it would be the Minister on advice from the West Australian Planning Commission. The local planning scheme should include CHRMAP recommendations where possible, including special control areas and potential special use zones, like for a coastal node, for example, and any building and planning controls suited to the scheme. So it can highlight challenges to be met across the forward planning period and adds to the potential for private landowners to be made aware during due diligence, although it's not guaranteed that landowners will do that process, but it does enable the local coastal manager to be somewhat on the front foot when it comes to coastal hazard planning and potential long-term planned and managed retreat. If the local planning scheme and any amendments are really ahead of the curve, they may progressively have space to increase allowance for foreshore reserves. Having said that, when you look at some of those other aerial photographs, you can see that any scheme or scheme amendment where there's already a limited foreshore reserve is going to have trouble creating an increased allowance. And what that means is in those areas, we may be looking at a more active planned and managed retreat of assets and property. So this is an example from the new City of Albany scheme, gazetted on the 27th of February 2024. That scheme was done post-development of the Emu Point to Middleton Beach CHRMAP. And what that meant is it was able to introduce, both the strategy and the scheme were able to introduce recommendations. So the scheme in Part 5 talks about special control areas. It says the special control areas marked on the scheme map according to legend that in the scheme map and the purpose, objectives, and additional provisions that apply to each special control area is set out in Schedule 8. If we jump to Schedule 8, you can see there the Special Control Area 10, Coastal Erosion Risk for Middleton Beach. So just looking through those notes, it talks about the purpose of the Special Control Area to implement adaptation options for assets requiring short-term management. And then these are the key parts of the Special Control Area, or the SCA. It identifies that all land and works within the Special Control Area require development approval, which is time limited. What's important about that is that there are a whole bunch of minor developments that are exempt from seeking planning approval and would progress directly to building licence stage. So this special control area, this SCA, catches any of those what would have been exemptions and brings them back into the planning system. And then the second part of the provisions within the Albany scheme is that that all development should be designed to be capable of removal within that special control area. It goes on to talk about development approval requiring a notification. So this is that notification on the certificate of title that we spoke about. And in this case, it says the notification states the lot is located in an area likely to be subject to coastal erosion and or inundation over the next 100 years, etc., etc. And then it also includes that limited approval, which I was talking about, that says the development approval shall cease to have effect and the development removed when, and then it provides the conditions upon when the development would be no longer effective. And then the last thing it says is that at the point where the approval lapses, the land shall be rehabilitated at the landowner's cost. So these are fairly significant conditions for an individual landowner to deal with. There's some advice there. Obviously, the first piece is that the coastal manager, in this case the City of Albany, may grant extensions to the time limit, and those extensions would be based on monitoring and observing whether or not those potential impacts are being achieved, like those event impacts. And so, of course, we're talking about events here. The first event being that the ocean is getting closer. So in this case, it's saying 35 metres. The most landward part of the lot is within 35 metres of the horizontal shoreline datum or the edge of the coast, or a public road is no longer available, or water, sewer or power is removed or decommissioned because of coastal hazards. And then obviously it gives some information about what is the horizontal shoreline datum and where are we getting it from for this particular clause, and also refers back to, as you can see here, the CHRMAP that was done. So you can see from this that the CHRMAP becomes a really critical part of how the coastal planning work is translated into day-to-day activities of the local government in the planning system. What's important here is that over time what you will see is the local government has a greater capacity to pre-warn people that there is a coastal hazard, and it won't be fast, so it will still take some time. But over time, more and more people will be aware about these coastal hazards, and so any future planned and managed retreat activities will be less of a surprise. And so we have this. So we'll have a very slow transition from the existing development as it is today through to a future where development may be relocated so that the foreshore reserve can continue to absorb some of the challenges. Jumping down to the local structure plan phase, again, local structure plans, a greater level of detail than you might have seen in the district structure plan. But typically what we're talking about here is a plan for a single residential neighbourhood, estate or a local area that looks at residential density, subdivision and coordination of infrastructure. So this is that next level of detail. And within a district structure plan, you may see smaller local structure plans be developed over time. A CHRMAP should absolutely precede a local structure plan. If one exists, the structure plan should reflect it. If one does not exist, then the developer of the local structure plan should develop it. Local structure plans are often developed by the private sector in more greenfield scenarios, and then can be developed by local or state governments for certain areas in a more infill development capacity. Local structure plans should include responses to CHRMAP recommendations, so any foreshore reserve setbacks, special control areas, special use zones such as coastal nodes, and any building and planning controls that may be required. A local structure plan can highlight challenges to be met across the future planning period and also increases the likelihood that private landowners will be made aware during due diligence. Again, this is that figure that I showed before, but essentially a reminder that what we're talking about is maintaining coastal foreshore reserves. So the local structure plan should absolutely be able to identify what the foreshore reserve is and provide for where coastal nodes are included within that foreshore reserve. So coastal node zone may be held in private ownership for a period, and that would be where there was a zone over the foreshore area before the structure plan was developed. The private entity would like to maintain the capacity to earn some income from that area, even though it's within the coastal zone. And so it is rezoned into a coastal node zone. Which would likely have special uses applied to it. It would certainly require long-term vesting to the coastal manager. Essentially what it does is it delays the vesting of the foreshore reserve to the coastal manager over a short period of time, but it would only be acceptable where it's intended to become coastal foreshore reserve. So now let's talk about the subdivision application stage. Essentially what we're talking about at the subdivision application stage is the breaking up of larger lots into smaller lots that you might sell individually. So typically for a local area, maybe a small or large subdivision. There is a difference between smaller subdivisions and larger subdivisions. Larger subdivisions quite often associated with bigger structure planning components, so they should have already been through some form of coastal planning assessment, whereas much smaller subdivisions might actually just be a subdivision of a couple of lots within an existing developed area, and I'll show you some examples. In all cases at the subdivision application stage, a CHRMAP should precede the subdivision. If it's not done, it should be completed prior to the subdivision approval to guide lot layout. The subdivision should reflect the CHRMAP and should comply with SPP 2.6. You can see there's a whole series of different references there, and this is obviously where those large subdivisions come into play. So it also includes things like ceding public coastal foreshore reserve to the Crown free of cost and creating coastal foreshore reserve, potentially even preparing an FMP, so foreshore management plan. The approving body is the WAPC. One more important element at the subdivision application stage. This is the time when the West Australian Planning Commission could apply a notification on the certificate of title. So as the subdivision application is progressed, the West Australian Planning Commission can approve the subdivision and place a notification on the title. The model subdivision conditions schedule includes this language. A notification pursuant to Section 165A of the Planning and Development Act 2005 is to be placed on the certificate of title of the proposed lots. Notice of this notification is to be included on the diagram or plan of survey deposited plan. The notification is to state as follows: this lot is located in an area likely to be subject to coastal erosion and or inundation over the next 100 years from the date this notification is registered. Notifications enable planned and managed retreat for zoned land. Now you might recognise that this differs slightly because this notification refers to Section 165A of the Planning and Development Act 2005, and that is because the West Australian Planning Commission, through the subdivision process, can use the Planning and Development Act for their notification on title, whereas the previous example with the City of Albany was referring to Section 70A of the Transfer of Land Act 1893. And that's important because the special control area provisions are typically dealing with, at the local government level, are typically dealing with development applications, where the relevant instrument for the notification is the Transfer of Land Act, whilst at subdivision, the application is dealt with by the West Australian Planning Commission and the use of the Planning and Development Act can come into play. Okay, one really important thing about subdivision, there's two types of subdivision. One would be assessed as infill and one would not be assessed as infill development. So if we look at the image here, we're talking about an existing superlot, for example, which is close to the foreshore and probably within the coastal hazard zone, but is consistent with the existing urban framework. It would be assessed as infill development and the notification on the title would be introduced. In this second example, they would create a new subdivision of development of private property within the foreshore. The policy and the guidelines say this would not be assessed as infill development. That means that a CHRMAP in accordance with SPP 2.6 is required to accompany the subdivision proposal. The CHRMAP would need to demonstrate that the coastal hazard risk can be adequately managed to ensure there's no danger to lives, property and infrastructure, and that new lots and resulting development and infrastructure are unlikely to detrimentally affect natural coastal processes. Again, this is important. The subdivision application on the left, small scale in existing urban area, and the subdivision on the right, slightly larger scale and probably needs a more significant planning process. So now we're getting into the really local level of coastal planning, and this is where we might be starting to introduce things like a local planning policy. Local planning policies are enabled through the planning regulations. Local government typically looks at a matter that needs to be dealt with and creates a local planning policy which it endorses through its council, through its elected members, within a single local government area. And in this case, it would be prepared to assist implementing the CHRMAP or coastal hazard planning. Obviously, the CHRMAP should precede the development of any local planning policy about coastal planning, and the policy should reflect SPP 2.6 and should be consistent with the CHRMAP. And this is where you might see local governments introducing notifications on titles as an idea and pre-warn potential developers or applicants that they may be subject to that provision. And there are a couple of great local planning policies that are reflecting existing CHRMAPs and other coastal plans, and you can find those examples in Joondalup, at Broome and in Port Hedland, and there's a draft one at Murray, which is quite excellent. I'll come back to those ones. And here we get to the last line of defence for introducing coastal planning in the planning framework, and that is through development applications, typically assessed by local governments, but depending on the scale, could also be assessed by the development assessment panels or the significant development assessment unit through the significant development pathway. Development applications should absolutely be preceded by CHRMAP in areas that are vulnerable to coastal hazards, and if not, a CHRMAP should be completed by the applicant. And the applicant should indicate how the proposal is consistent with the CHRMAP. If it requires approval, for example, in a special control area, approval should only be granted on a temporary or time-limited basis per the CHRMAP and can be linked with an event-limited approval. Notifications on title should be introduced. This is also relevant to private development and leasehold approvals. So looking at the Point More example, which I will describe a bit later, making sure that any leases are also considering CHRMAPs. So to wrap this up, I guess the key point is there are different levels of coastal planning required at different stages and different mechanisms that we would introduce at different stages. I'll describe each of them in a little bit more detail, but essentially if we look at it at a high level, we're looking at a coastal hazard assessment. So basically understanding the potential vulnerability, and that's enabled through state planning policy. And then we might deliver the CHRMAP, also enabled under state planning policy. So that's the full detail of stages 1 to 7 of the CHRMAP process. We might also, at that next level of detail, which has slightly more detail on actions, develop a coastal planning strategy, or a foreshore management plan, so a CPS or an FMP. And all of that so far is sitting at that state planning policy level. And then we get into the special control areas within the local planning framework. And of course, special control areas are a recommendation of higher order coastal hazard planning, but they are implemented fundamentally through the local planning framework. This is the same with limited planning consents, which are implemented through the local planning framework, and notifications on titles through the local planning framework. And as you can see here, these local planning actions are setting the groundwork for longer term planned and managed retreat so that future generations do not have to bear the cost of coastal hazard adaptation. And as I mentioned before, no coastal manager wakes up and decides it would be fun to introduce all of these controls. Typically, people are worried about their assets, worried about public assets, and worried about the environment and safety, and then action is taken. It's fundamentally about risk management and trying to avoid future risk. It is probably worth noting that a CHRMAP is not always needed. Typically, when it is needed, it's because it's necessary in the planning continuum. So we want to make a decision within that planning continuum that I've described that needs the CHRMAP to be completed in order for good decision making. Or secondly, because physical assets, private and or public, are located close to the coast and are either currently or likely to be impacted by coastal hazards within the planning timeframe, so within that 100 years. And so what's happening in that scenario is responding has become necessary and risk management is simply part of business as usual in that case. But it might also be overkill to do a CHRMAP. And that might be an example, say, if you are not near the coast or inland water linked to it. So if you're in inland local government, coastal hazards probably not your major issue. Plenty of other things in the planning system that might be concerning you, but it's unlikely to be this. It might also be overkill where there are no physical assets. So where it's a natural environment and the natural system can go with the ebb and flow of erosion and accretion cycles, and you've got plenty of space for that to happen. And of course, it might also be overkill when the assets that are visibly vulnerable or considered based on a reasonable rule of thumb to be vulnerable have very low asset value or have more than adequate room to move. So in that case, we would argue that it doesn't have to be a large, expensive exercise. It might be beneficial to document the decision-making of that asset management, but it's also maybe okay to have a low-risk item in an asset management framework that you simply say is low risk, and if something happens, you can relocate it. And this is an example of an area, this is sort of southeast of Augusta. It's very remote, it has limited access. I've just drawn a little access track in here. That access track is probably majority accessed by fishermen and surfers, and it's not close to any major assets. The natural environment has plenty of room to move, and it's simply a spot where a small number of people will visit, and it's unlikely that large assets of value will be impacted by erosion over several hundreds of years, I would think, in this location. Having said that, if we look at the actual location where access occurs on the coast at the end of that little drawing that I drew, this is the coastal access path. You can actually see the four-wheel drive tracks. Over time, due to the activities, there might be a temptation to introduce assets. So perhaps the local government at some stage says, lots of people are accessing this. Let's put some bins and maybe a car park in off the coast in this location. And in that case, then you might require the development of some kind of plan to manage the access, but still probably not a CHRMAP. So you might have a foreshore management plan or a specific asset management plan for this location, but not a full-scale CHRMAP. Obviously, it's important to note in this case that the more assets you introduce, the more people will visit and the more they will get attached to the assets that you have there. So that creates different challenges in the future. And that's always something worth thinking about in any foreshore or coastal zone. So looking at a couple of examples of CHRMAP delivery. So here's a few notable examples. Sea rescue building and cottages at Point Moore are a really interesting example. The cottages were at high risk of coastal hazards. Leasehold arrangements were created to enable some flexibility by enabling conditional private ownership of the lease in hazard zones, but the right for termination of those leasehold arrangements in the case of inundation and erosion risks. So continuous use of the land, but with limits. And then, of course, the Sea Rescue Building at Point Moore, Volunteer Marine Rescue Building, there was a recommendation for demolition and removal with triggers written into the CHRMAP, and those triggers were met at a rather rapid rate based on several years in a row of rapid erosion, and that building was in fact removed. So there's two examples of both leasehold and a public asset where continued use and enjoyment was enabled through the CHRMAP and through the planning system over time, but also action was enabled by the planning system. Conversely, we look at the Sea Rescue Building, the Lookout, and some private properties at Lancelin. Now, Lancelin's at a high risk of coastal hazard. Freehold properties are at risk of inundation, erosion, and there's much less flexibility for freehold properties. As I noted before, the capacity for notifying landowners comes about as a result of subdivision or development application. And if you've got an area which is not going through a large redevelopment phase, you might not see either of those two circumstances over a long period of time. The Sea Rescue Building has been identified for demolition and removal at a certain point in time when the coast is so close to the building that it does need to be removed, and the Department of Fire and Emergency Services has identified an alternative location. So they're ready to go, and the CHRMAP will guide their adaptation actions over the longer term. In terms of the public foreshore, the CHRMAP is guiding short-term actions. So there's been some sand nourishment there recently after a series of big storms took out quite a lot of foreshore. And so again, the CHRMAP is guiding good actions there. And of course, a big impact recently, the Lookout at Lancelin, through those same large series of storms, was essentially taken out and was removed rather rapidly. That action was able to be taken because the CHRMAP was in place, and it enabled the local authority to say, yep, this is probably not the right place to return this asset once the beach accretes again. However, in a more complex state are some of the private properties at Lancelin. So they are also impacted by these storms, and in particular last year's run of quite significant storms. And a number of private properties, including the pub, have lost coastal frontage. And so this is where we start to look at mechanisms like notifications on titles and time-limited approvals. But of course, as I noted previously, notifications and time-limited approvals require a subdivision or a development application, and Lancelin's not seeing a large-scale redevelopment at the moment. So it will take some time for those mechanisms to be in place. Unfortunately, due to those mechanisms being a bit behind pace with the erosion that's occurring, there's much less flexibility for the planning framework to respond to adaptation needs. And so more detailed planning will need to be undertaken to understand what's required for planned and managed retreat of private development within Lancelin that is impacted in real time, sort of in the current time frame. Another well-known example is the North Fremantle car park and the coastal pub there. It's leasehold and private investment is obviously at risk, and adaptation responses, including sand nourishment, have been implemented following the CHRMAP, short-term adaptation actions. So now having a look at a couple of other examples. So these ones are protection recommendations from CHRMAPs. So there was a buried seawall recommendation at City Beach and Middleton Beach, and they were implemented as part of a CHRMAP. They were planned and undertaken at a time where the appropriate care could be given to the adaptation response. Alternatively, you can see the example of the seawall that was constructed at Seabird. This was done quite rapidly based on some erosion that was occurring locally and impacting private properties, and based on the speed at which the adaptation response was implemented, some key elements were not properly planned through, including things like basic funding and maintenance of the seawall. So the implications of that are now recognised. The seawall requires maintenance that is above and beyond the capacity of the local authority. And then this last example, which is a slightly different one, this is the Cocos Keeling Islands CHRMAP. The Cocos CHRMAP includes a recommendation that recognises the significant cultural and social dislocation and the human rights challenges associated with retreat entirely from a home. So it seeks to slowly implement retreat. It's likely to include some sacrificial protection measures, seawalls, and sand nourishment potentially, that decision makers know will be impacted by coastal hazards in the medium term, but it is a recommendation of the CHRMAP for short-term protection and long-term relocation. Here is an example of some leasehold conditions. So this is the Point More example that I was referring to. Essentially, the conditions are acknowledging the potential impacts on the premises. It says the lessee accepts the land in its present condition and acknowledges that they are located close to the Indian Ocean coastline and that coastal hazards may cause a challenge in the future. It then goes on to say that the lessor, i.e. in this case the City of Geraldton, doesn't expressly warrant that the land will remain suitable for all of the purposes that the lessee conducts thereon. So this leasehold condition is essentially saying that if at some stage in a future time the site is impacted, the lessee accepts that that is the case. Something that says, please be aware, and that in the future something might happen that requires this development to no longer be here. Of course, CHRMAP is not an endpoint. It's often just the point in time with the most contemporary data, often with gaps recognised, and it enables local coastal authorities to begin a longer-term adaptation planning pathway. More than likely will include different engagement, review, and updating of planning over time. And essentially, it's helping stakeholders and landowners understand potential impacts and obligations. And of course, regular review and may be amended to reflect increased risk over time. So some of those alternatives to CHRMAP assessment that I mentioned, so this is a coastal hazard assessment. Fundamentally, this is the research and technical investigation components of the CHRMAP. It's introducing the core technical aspects of the CHRMAP without the detailed engagement or recommendations pathways. So this might be done as a precursor to a CHRMAP to determine how significant coastal vulnerability is. A good example of that is the Coastal Vulnerability Assessment at COCUS, which essentially identified what the challenge was going to be so that the government could consider its next steps. And another good example is the blowholes management plan. And this is where there's limited or no private assets which are located or potentially impacted by the coastal hazard. And the coastal manager has room to move assets out of the way over time. So that project had a high-level coastal hazard assessment, and then the management plan was developed as a response to that. Another example of interest is the Swan Canning River Park hazard mapping project, which is currently underway. That study will hazard map the river areas and provide improved guidance for estuary and river areas for the local governments along the edge of that strip. And it's not a complete CHRMAP. So individual local governments will still need to, as coastal managers, undertake relevant planning. And good examples of that are the Ashfield Platts Master Plan, the Windown Guildford Locality Plan, Nedlands Foreshore Management Plan. They're all planning that's being done at the local level that in the future would benefit from this Swan Canning River Park hazard mapping project being undertaken already. And of course, hazard assessment is usually undertaken by coastal engineers and coastal modellers, and that's obviously worth knowing when looking at this aspect, because it can still be quite expensive even if you're not going through the whole CHRMAP process. And the other thing to note is that local coastal hazard assessments could be done later in the planning continuum. So perhaps you've already been through the structure planning process, the CHRMAP's done, you've got a subdivision plan that's getting prepared, and you need to do that local coastal hazard assessment to ensure that you have the right level of detail at that higher level of accuracy at the very local level. Next up is the idea of a coastal planning strategy, which I've mentioned before. So a strategic document earlier in planning or as a recommendation of a CHRMAP is also possible. Examples of this are, say, a large local government with an extensive coastline, particularly in the north of the state, but the majority of the coastline is undeveloped. So the CPS could guide areas outside of settlements, while a more detailed CHRMAP could deal with the developed areas, such as the coastal planning strategy for Karratha. Or the case in Kalbarri where the CHRMAP isn't proposed for some of the areas, but guidance for decision making is required. So there's access and four-wheel driving and heritage and natural environment management's required. And the coastal management strategy is providing guidance for that management of coastal and human use impacts on the foreshore reserve. Now, I think it's important to say at this stage, a coastal planning strategy, a coastal management strategy, it can be called all manner of things. The name is not necessarily important, but the content is, and that's per section 4.8 of the State Coastal Planning Policy Guidelines. And a coastal planning strategy might be more consistently developed by planners and landscape architects. And as I noted, this could be the broader scale planning for coastal areas, whilst the CHRMAP might deal with areas that have more significant assets. But it could also be that this is a recommendation of the CHRMAP to deal with the more sparsely developed coastline outside of a major settlement. Next up is a foreshore management plan. So foreshore management plan or similarly named thing, foreshore master plan, land use master plan, management plans, all sorts of names. Typically later in planning, so often, much more often as a recommendation of the CHRMAP now, although we used to do foreshore management plans or foreshore master plans quite commonly before CHRMAPs existed, and they dealt with the same elements. It's just now that we have coastal adaptation planning, we are much more capable of introducing those constraints as well. Great example, CHRMAP has identified localised coastal foreshore that requires more detailed management, so a coastal node. And that includes things like revegetation, relocation of older assets, the management of paths and four-wheel driving and parkland, etc. So this example on the right is the Coogee Beach coastal node, and the City of Cockburn did a foreshore plan for this. They called it a land use master plan. And that essentially identified long-term adaptation responses. And you can see in the image that Coogee Beach includes a caravan park. And this is a great example of how a CHRMAP created the conditions for leasehold conditions of approval linked to coastal hazard planning and relocation of assets over time, whilst also allowing that leasehold to continue, but also enabling the City of Cockburn to look at other aspects like the cafe and the Surf Lifesaving Club and think about their long-term asset location. Another example is in Port Hedland. They called theirs a coastal foreshore management plan, and again, management of key aspects of the foreshore as a response to the CHRMAP that recommended that management plan. Another example is where the coastal manager has identified emerging management needs. A good example of that might be the Augusta example that I showed you earlier, where the coastal manager sees some four-wheel drive trail management that's required and wants to ensure that the four-wheel drives stay on the right pathways. Quite often, planners and landscape architects are the key disciplines involved in foreshore management planning, but we can also be talking about environmental scientists for flora and fauna assessments and coastal engineers if there are other factors that need to be introduced, such as seawalls. And like I said, foreshore management planning used to be undertaken quite consistently in isolation of CHRMAPs, but now they are much more linked, and that gives coastal managers the ability to really assess the coastal hazards that they're planning for and make very detailed asset management responses. Guidance for a CPS and FMP is in section 4.8 of the guidelines. You'll also see information in the Coastal Planning and Management Manual. There's also information about these documents in Guidance Statement 33 of the Environmental Protection Authority, and the guidelines for developing foreshore management plans in the Swan Canning River Park. Fundamentally, they include a number of really consistent factors, so taking into account environmental factors, looking at opportunities and constraints, setting out requirements for foreshore reserves and public use and access and facilities, and then looking at form and scale of development, foreshore tenure and management, and the location, form, and land use within the node. And here's just 3 separate contents pages from 3 separate documents. You can see the consistency, words like flora, fauna, geology, soil, etc. And the second example, if you look through that, you can see the same types of language. And this last one, again, you can see the same types of language. Okay, so what happens after coastal planning is done and dusted? The simple answer to that is it's never done and dusted. But let's have a look at what you as a coastal manager would need to do once some coastal planning has been undertaken. So the one I've referred to many times already, the special control area. So either during the scheme amendment or during a full scheme review, you would be expected to introduce a special control area to identify the coastal zone and to create conditions that require development approval in the coastal zone. That might be supported by policy controls prepared to align to the CHRMAP or other coastal plans. And the examples that I used were Joondalup, Broome, Port Hedland, and the Shire of Murray. I like Joondalup because it's really explicit about property reports from settlement agents, so that settlement agents are consistently aware that there's a coastal hazard. Murray and Broome are very clear about the conditions of development and what's exempt, and that means that you potentially can allow for some minor exempt development like a garden shed or something like that, while still being able to go through the development application process for a larger development. And I really like the fact that Murray and Port Hedland's policy is really explicit about subdivision and what can and can't be allowed and what will require a notification to be placed on title. And of course, the CPS and FMP. So developing those documents will take a longer time. They are more expensive, and you're certainly going to be obliged to do engagement through that detailed design process. As I said, there'll be other technical studies like flora and fauna assessments. The CPS and FMP might also require a transport analysis if there's car parking in the foreshore or access to the foreshore, for example. And essentially, these documents would more typically guide the coastal manager's activities rather than private development. So you can take a little bit longer, provided the coastal manager is still meeting its obligations under SPP 2.6. So then we jump to approving development in the coastal zone. As I mentioned before, notifications being time limited and event limited. So with an obligation on the property owner to remove or relocate at a certain trigger. Again, those triggers, for example, if the shoreline is within a certain distance of the property, or if the primary road access to the property is lost due to erosion hazards, or if the removal of power, water and sewer occurs and so the site is no longer serviced. Approvals could include the provision for extensions of time for the approval. For example, the Albany example, if at the time that the approval is due to lapse, those triggers are still a long way off. It is worth noting here that there is potential slow long-term impact to property values if these notifications and obligations are placed over land owners. But it is also true that over time, the visibility of coastal hazards are also likely to impact property values. So it's not simply a factor of the planning control that property values may change over time, but in fact, the simple fact that the coast is changing. There is also a potential for the notification to encourage alternative transportable building models. So that's again enabling improved adaptation. And it's really worth saying that this has been successfully implemented in many jurisdictions and is quite established in the planning system. Okay, there's also other things that can be introduced at the development application stage for development in the coastal zone. This would typically include things such as building controls for minimum finished floor levels for buildings, normally for inundation challenges. There's a couple of local planning policies that have been developed that have dealt with such things. and have been in effect for quite a long time. And Albany and Bunbury are great examples where local planning policy has existed for more than 20 years to introduce finished floor level requirements, building form, etc., to manage inundation challenges. Local planning policies could also introduce building envelopes on larger lots, so further away from the coastal zone if the lots are deep, or introducing different types of building form, so more transportable development. Fundamentally, these types of controls are similar to bushfire building requirements, so they're one more risk management tool to make sure that buildings can withstand hazards. And again, as we've mentioned a few times, notifications have limitations. They can only be applied where triggered under subdivision or development application. So it's not ideal, and sometimes you are catching up. But building controls combined with notifications is one way of trying to fill the gap. And of course, it is important to note that unless you change the zoning of the land, which may result in injurious affection or compensation, existing rights continue. So a local land manager, a local coastal manager, can't simply refuse something because they know it's in a coastal zone. They can only create conditions of approval within the existing use rights of that land. So what about coastal activities in public foreshores? So these are noted specifically as variations within SPP 2.6. So the creation of public recreation facilities, barbecues and paths, etc., is permitted. Relocatable coastal structures, so dune fencing and sunshades, also permitted. And this is all part of coastal nodes being recognised for their need to occur close to the coast when they're appropriately located, obviously. For example, something like Hillary's, a boat harbour on the coast, is obviously fundamental to the boat harbour, and then the assets and public facilities within that boat harbour are there to improve and increase enjoyment of the coast. Surf lifesaving clubs are also variations, marinas, ports and aquaculture, which rely on water, and defence infrastructure, also variations that can be located in the coastal zone. However, what would typically precede activities in the coastal zone is some form of planning, so a foreshore management plan or a coastal planning strategy, and that should be preceded by a CHRMAP, and that should describe what can and can't happen in the coastal zone. Obviously, it doesn't explicitly exclude development, it just could limit it. So it might include things like 21-year leases for more substantial assets and removal at the end of the lease, or it might include assets that are more than likely going to be at the end of their life cycle before the coastal hazard impact is experienced. And it's important to note that some coastal assets require environmental impact assessment, and the Environmental Protection Authority coastal factors will also be considered in those things like marinas and ports and aquaculture. Notwithstanding, I would say that some of these assets, like a surf lifesaving club, is a pretty significant infrastructure investment, and coastal managers should be careful about their location and how easy they are to relocate over time, and also how attached the community becomes to those assets. So, what about existing development in hazard zones? So, this is a bit trickier. So, public land. Public land may continue to be used with asset management, with retreat planning, so those foreshore management plans, for example, with limited leases, with construction of temporary facilities, and relocating things where necessary. So, you can see my little image there of a park bench, and those lines are drawn to replicate the sorts of lines we would show in a CHRMAP as periods in time where the coastal hazard zone might come increasingly closer to assets in the foreshore. And at that time frame where you are projecting that the asset may be impacted, when that park bench needs to be replaced, rather than putting it in exactly the same spot, you just move it a bit further away from the coast. It may also include some property acquisition to increase the area of public land on the foreshore. SPP 2.6 talks about coastal protection for this type of public development as only being supported where it's demonstrated there's no significant negative impacts on the adjacent environment and in conjunction with appropriate funding arrangements for the construction and ongoing care, control, and maintenance being in place. But let's look at what it means when we're talking about private property. And a big question we get asked often is, can private property owners protect their property individually? There's probably very few cases where the answer is yes. So preferentially, the answer is no. There are cases that might exist, and that would include places that are really remotely located properties where the conditions of SPP 2.6 are met, and that would be that it's demonstrated there are no significant negative impacts on the adjacent environment and that appropriate funding arrangements are in place. So collectively, possibly. So if you've got a large group of landowners that are all impacted and they are all committed and they have all agreed to apply the appropriate funding and that's in perpetuity, then perhaps the local decision making could be, yes, they can undertake their own protection, but that would have some conditions associated with it. Almost certainly that any protection would need to be within their private property boundaries, that appropriate conditions on removal could be introduced if SPP 2.6 is no longer being met. Of course, there would be some form of indemnity to the coastal manager, so any protection structures would be the responsibility of those private parties. There would certainly be notifications on title, and you would imagine that there'd be some kind of relationship between the rates that those landowners paid and the ongoing care, control, and maintenance of those assets. So potentially special rating would create some form of bond to make sure that those ongoing funding arrangements are met. And I think it's fairly clear that there is a strong preference for publicly led management of protect pathways to ensure that it's part of broader land use decision making, to ensure that it's in the public interest and maintaining the foreshore reserve and public access. And that example that I showed earlier where public access is not available with private properties running straight into the foreshore area, that isn't maintaining public access, and therefore the public is not experiencing the amenity of that coastal foreshore. Obviously, protecting private property would be undertaken if it's evaluated to have limited impact on adjacent coastlines, and of course, if it reflects community expectations. Really important, all conditions of SPP 2.6 would need to be met, including funding. Here's an interesting example of protecting private property. What if the coastal manager can't afford protection? In that case, retreat is the most appropriate pathway, and that can be either one of two pathways. And that could be a do-nothing retreat, which is essentially letting it fly, or a managed retreat, so planning it. And the City of Greater Geraldton had a look into a variety of different mechanisms. So they discussed alternatives. Under a do-nothing approach, they were saying that over time, what if they resume properties under the Health Act, so condemning them on the grounds of public safety? They recognised that this would be potentially bad for their reputation. Their second alternative was creating a planned retreat pathway, with the city acquiring properties at risk over time. They certainly recognise the costs that would be associated with that and the requirement to exercise that mechanism through different acts and legislation. But they did recognise that that would create an increased coastal foreshore. And then the third was looking at coastal protection options to protect those properties managed by the city, but they very clearly said in this case that costs would have to be applied to each of those individual landowners. And that is the beneficiary pays principle. So Geraldton's done a good piece of work here in thinking about the variety of different ways that retreat could be affected. I mean, benefits of this, certainly short term, it could include a lease back. So you could start to acquire properties under the planned retreat scenario and then lease back development until such time as you need to demolish the development. But the long-term outcome is that private land is returned to public foreshore. So then we come to, what if beneficiaries can afford protection, but it impacts public amenity? So this would require application of SPP 2.6 and the public interest test. And it is unlikely to meet the conditions of SPP 2.6 if it does impact on public facilities or adjacent shorelines. So it would be unlikely to be supported. There are situations in the past where private properties have been protected and perhaps these conditions of SPP 2.6 haven't been met. But it is worth recognising that as our understanding of the impacts of coastal hazards increases, so too does our response to them improve. So, how it all fits typically, and a reminder that there are some historical anomalies based on different planning frameworks being developed at different times. Going back to that flowchart that I showed earlier in the training session, here we're looking at high-level regional and sub-regional strategic planning, including some kind of coastal considerations, and then local governments or local area CHRMAPs being developed, or a developer-led CHRMAP. And of course, all of that feeding back into the local planning scheme and through back into any reviews at that regional scale of planning. And it's worth noting that EPA coastal factors are also part of this higher level, noting that the CHRMAP would inform development adaptation strategy responses, which may impact the EPA factors of coastal processes and landforms. So the local planning scheme then influences the introduction of special control areas, that local government-wide and local area CHRMAPs influence coastal planning strategies, local coastal policies, foreshore management plans, coastal node or special use zones, and obviously in the blue there, any adaptation responses that require funding, contributions, or design and delivery. And that feeds into, again, from that higher order to the lower level, things like recommendations for notifications on titles, building controls, and special use provisions that directly impact individual local landowners. So CHRMAP pathways set adaptive responses over time, enabling change progressively, and obviously all of the underlying documents after that point would be assessed to be compliant with the CHRMAPs, and that compliance must be demonstrated, of course, also including regular review of CHRMAPs. More simplified, regional, local, detailed local, and then directly to individual landowners. In summary, coastal planning is a whole of system risk management approach in planning. It starts at the very highest level of thinking and strategic planning and weaves its way all the way through to the individual lot level of detail. It's certainly complex, but being prepared is better than being caught out. And there are so many cases now and examples that you can pull from of local authorities being ahead of the curve rather than having to make ad hoc decisions. Planning tools obviously should fit the scale and context. You do not need to spend an enormous amount of money if there are very few impacts being experienced. But certainly, if you can see coastal hazards in real time and you don't have a CHRMAP or you don't have a coastal plan of any description, you should be starting to think about it. Fundamentally, coastal hazard adaptation planning is designed to ensure orderly and proper town planning, so sustainable use of the coast and providing for continued access and the protecting of values. And so, while some urban areas are well advanced and policy is catching up, particularly in our region scheme areas where we're highly settled already, or adaptation has been implemented that may no longer seem suitable, there will be anomalies. But these are becoming fewer, and the great examples of exceptional coastal planning are all around us. Plenty of examples in this training module, and in the supporting fact sheets, and also plenty of information in the other training modules as part of the CoastWA training series. I encourage you, if you haven't already, to look through the different modules that are there. So much more information than can possibly be fit into this one training session. Please don't hesitate to contact the Department of Transport, Department of Planning, Lands and Heritage, WOLGA, or CoastWA. There is plenty of support out there. And a final thank you very much.